Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is Don't Sign a Release Until It Passes This Checklist. So without further ado, I'd like to introduce the fabulous and wonderful Jessica Murphy.
Thank you so much, Jessie. I always appreciate the opportunity to talk to your audience here. I love education, love construction. I'm a daughter of a construction worker, had a construction company when I was born, so grew up in it. Love what I do and love talking about it. So hopefully I can give everyone a little bit of information as to what to look for releases in construction contexts. And my goal today is really just that maybe you take away one thing from this, or at least pat yourself on the back for doing it all right. So without further ado, we'll get going. If you have any questions, there is a chat box on the panel. We'll answer all the questions at the end. Please don't include company names or anything too specific to your situation. The more general you can make it, the easier time I'll have answering your question. If you do have anything specific at the end, feel free to reach out to SunRay or myself directly. Always happy to walk through a situation with you if you've got something going on. So here's what we're going to go through today, and I'm going to try to maximize our 20 minutes together. So we're going to talk about what a release is, special types of releases, specifically the Massachusetts Mechanics Lien release. We're going to talk about lien and bond release considerations. Go through a release checklist. Here's what you should look for every time you have a release presented to you. And talk about the right ways to exchange a release for a check. Yes, there are right ways and wrong ways. And then we'll talk a little bit more about your SunRay resources and how they can help you. So let's go get you released. All right, so starting with the basics of what is a release, just to know that a release in general is any agreement that's going to have you give up your rights in exchange for something else. So you typically want to be getting payment, but maybe you're going to be doing a walkaway, so there's no payment. A walkaway is when both parties just leave as they are, and typically that really just includes an agreement not to sue. So releases can be what we call a general release, and you may see this in the term, in the title of the document. It says a general release, although you do have to read the language below. You should be clued in that they're looking to release all claims between the parties, no matter what subject matter, no matter what date, no matter what project. You may also see something that talks about a limited release. A limited release is address only specific projects or specific claims or specific time frames. So limited versus general is one of the first things to take a look at. And again, that may be in the title of the document, but you don't want to rely just on that. You do want to make sure to read the entire document to make sure you know what it is actually talking about. There's no specific language that's required for a release. You may see words like release. You may also see words like remise, waive, or discharge. Sometimes you're going to see all four of those. There's no magic to which words we may use or may not use. And a lot of times when we're talking specifically about a Massachusetts Mechanics Lien, we're actually going to be talking about a waiver as opposed to a release. But those words really are used interchangeably. And what you should think about when you see any of these words is that you're giving up rights. So you want to understand what it is that you're getting back and the scope of what you're giving up. It does require consideration from both parties to be binding. So if you are getting something, someone just says, I promise I'll pay you on Friday. There is no consideration for that promise. It's just a bare promise. If they say, if you don't sue me between now and Friday, I promise I'll pay you on Friday, there's consideration there. The consideration is you're going to get money, you're going to agree not to sue. So you're giving things up and getting things. But without that mutuality of what's legally called consideration, it's not enforceable. So if someone just makes a gratuitous promise to pay, always good to get that in writing, but that's just a promise. If you're not giving up something in exchange, then it's not going to be a valid release agreement. You can have a release that releases claims by one party, or you can have a mutual release. If you are in agreement that this resolves all of your claims, I always feel like it's a good idea to include a mutual release, because then both parties know that for certain this entire matter is resolved between them. All right, so moving on from what is a release, let's talk about specific types of releases that you're going to see in construction context or in the supply context. Massachusetts mechanics lien release is a big one. It's very important to know that there is the Massachusetts mechanics lien statute, which is Massachusetts General Laws, Chapter 254. One of the most important things it says, and one of the most important things I find people constantly doing wrong, is that the contract will say in advance, as you sign up, that the contractor or the supplier or the vendor or the sub agrees not to file a lien and agrees in advance to waive your mechanics lien rights. That is void as against public policy and unenforceable. I tend to like to strike those provisions of a contract if you're editing a contract, because they are not enforceable. But do know that if you don't have the leverage to do that, or someone's not interested in making changes to the contract, not to worry. Whether or not you sign a contract that says it or not, by law, it cannot be held against you. Once you perform work and you start to have money due, then you can release your mechanics lien rights as you're going along. But again, there cannot be a contract that you sign before doing any work that says you agree to release your mechanics lien rights. And then if you file a lien, they do not have the ability to use that document to say, see, you said you wouldn't file a mechanics lien. So that's the good news. Massachusetts mechanics liens do have two different forms. One is a partial or a final. It is important to keep in mind what it is that you're signing. A lot of times they will be actually titled partial lien release or final lien release, then also called waiver. So it's or final waiver of lien. Regardless of what the title says, that should only be an indication to you of what's in the document. Do you want to read the document in full? Because the partial is essentially saying for payments, for work performed up through X date and payments received through X, Y date. So you're going to have some standards for the partial as to what it includes. It's not the full job. Final lien release is at the a good owner is, or a good GC is going to require partial lien releases for every payment. And then at the end, they'll get a final lien release. So you can go ahead and do that. The nice thing about partial lien waivers is they're frequently drafted with disputes included in there. So it is okay to do a partial lien waiver or release if you still have a dispute, so long as the dispute is noted in there. There is a form in the Massachusetts statute, Chapter 254, Section 32, has a partial waiver and subordination of lien form that is specifically designed for general contractors. So I'm going to skip to the next slide here. I know this is small, but I just wanted to give you a quick guide. This is actually a quote from the statute. It says that you are can enforce a lien if it is in this form or substantially this form. As you can see, it does have the title, partial waiver and subordination of lien. You would fill in the county in which it occurs, the date, application for payment number if you have that, some type of invoice or reference. It very much helps to tie the work in that particular application or requisition or invoice to what's actually being released. So that's a nice match to have there. Owner, contractor, lender, or mortgagee, that information gets filled in, and I would suggest that you want to fill it in as fully and completely as possible, full legal names. The nice thing here is you can see 1 through 10 identifies for you the different parts of the amount due. It will explain, obviously, the contract balance, if there are adjustments, what the adjusted contract balance is, then if there's retainage, payments made so far, figuring out what the current balance due is, and if there are pending change orders or if there are disputed claims. So this gives you the opportunity in a partial lien waiver. If, let's say, you're doing requisition number 5, you dispute some of those charges, you can still get paid for the balance of the charges you don't dispute. And you can preserve your lien as to the undisputed claims as long as you're filling this out correctly, meaning that you're putting an amount in the disputed claims section. I would always prefer that this comes along with some explanation of the dispute or some notation so that they understand what the dispute is. But this will allow you to, again, both get paid, waive the undisputed portion of your lien, and allow you to retain the disputed portion. Also note that this is something that's signed under the penalties of perjury because typically these forms are required to be done by a notary. You may also see a notary stamp in there. So again, if you're looking for this form, it is a statutory form. It is contained within Chapter 254, Section 32. You can copy it directly from there and fill this in as you go along if you're using this. You can also, if you get presented with a lien waiver, you can take a look and see if it complies with this. One of the keys that we'll talk about in a moment here is that lien waivers often have a lot of additional language that may try to broaden the scope of the waiver or the lien to things beyond just the mechanics lien rights that you want to waive. So moving on to bond claim releases. Bonds are only required in Massachusetts on public projects where the project itself, the prime contract, is for $25,000 or more. That's contained in Massachusetts General Laws, Chapter 149, Section 29. Any bond that you get in addition to that payment bond is going to be basically an additional bond that is just given because the parties want it to, and therefore it's going to be contractual rights that relate to that bond claim. Similar to Massachusetts mechanics lien claims, you cannot waive bond claim rights in advance. So again, if you're being presented with a contract at the start of a project and it has a term that says, by signing this, you agree that you will not file a claim on the bond and you forever waive your bond rights, that is not going to be enforceable. Bond claims can be waived or released by any particular type of form. There is no statutory form like for a mechanics lien, and there is no language. Bond claims, once you get started and you have accrued a claim, you can then waive that as part of a resolution by any form of a waiver or a release that you're going to sign. So here's the special release considerations that you need to think about here. We talked a little bit about this. For Massachusetts mechanics liens, they cannot be done in advance. You cannot have that blanket waiver from the initial contract. They can only be waived as you develop those rights, then you can waive them, provided that you're getting consideration back. Key here is going to check the scope of any documents that you're given. It may look like you have been given the statutory form. They don't have to use the statutory form for a release. They can. It's a safe harbor, but they don't have to. They can use any kind of general form that follows that. But they may also add in some additional language. So do parse it through carefully. Read the entire release, because you want to know, are they now saying that not only have you released your mechanics lien rights, but typically what I see is that you're releasing all rights. Now, you may find that at the end of the day that there is something done that you weren't aware of that relates to that scope of work. You certainly want to make sure that you haven't released any additional claims beyond what you are sure that you're releasing. And typically the minimum mandatory is just going to be your mechanics lien claims. So strip it back down to that if you're the one executing the release. To be enforceable, also keep in mind that you must receive the stated consideration. So if we go back and take a look at the form, it does say this last line, the undersigned who has a contract with so-and-so for furnishing the following releases them upon receipt of X dollars. That's the end of that first paragraph. And the idea of that is that it's telling you how much money you're getting in order to release your claims. So if you were to receive a check and the check bounces, despite the fact that you've executed a mechanics lien release, you no longer have released your claims because you did not get the stated consideration. In Massachusetts, for bond release considerations, the only thing additional that you need to know for bonds is just, again, it can't be done in advance as a blanket release in the initial contract. But there is no particular form. There's no statutory safe harbor. you can have it done in any way that you would handle any other type of release. So typically the way that works is if you had a bond claim, the bond company is likely going to say, okay, if we're going to settle this, we're going to pay you, we're all going to walk away, but we're going to send you a release form. It's going to look more like a general or a limited release form without that specific structure of the contract plus the additions minus the payments. It's going to look more like just a paragraph of text that says, I release my claims, including claims under bond number XYZ. So this is the real thrust of what I hope you take away from this. Here's a release checklist. Don't sign a release without checking that these things are there. For anyone who's heard one of my presentations before, I'm big into this acronym RTFC. That stands for read the blank contract. Always want to make sure that people read what they sign. It should be written in English enough that everybody can understand it. Myself, I don't like to draft documents that have a lot of legalese to them. If you don't understand it, ask questions. Ask questions of the other side who's giving it to you. Ask questions of your attorney, but make sure that you're asking questions and getting the answer. And if the language is confusing, have it rewritten in a way that you understand. Make sure that the parties are properly and fully named. Massachusetts, that has a Secretary of State's website, as does almost every state, that is free and publicly available. Go online, plug in the name of the company, and make sure that you're figuring out, are they an active and properly formed company? Are they an LLC? Are they incorporated? Or are they a partnership that has no real protections? Or maybe just a DBA name? Check it out and make sure that you know that they are there and that the proper parties are being named. Consideration, again, it's that what are you giving up of value? Typically, if you're giving a release, your consideration is you're going to get paid for it. But make sure the consideration is stated. If there is some sort of consideration that says, hey, if you release this mechanics lien, we're going to pay you half of what we owe you, but we'll catch up because we'll give you a couple of new jobs. If that second part is not stated in the release, it is not valid and enforceable. So if it's part of the understanding, build it into the written term. Otherwise, you can't hold anybody to that. And if they're not willing to put it in writing, they may not be willing to honor it. Make sure that you check that the scope of the rights being given up is fully and clearly articulated, that it's not broader than you mean it to be, that they haven't slipped general release language in, and if it's just a mechanics lien release. And again, the scope being, is it a partial or full? Those types of waivers and mechanics liens are important. When you get to the point of getting a final lien release with mechanics liens, you're typically going to see language that includes that broader scope, that now the project is done, you are giving up all your mechanics lien rights because you're being paid in full. And in turn, since the project is done, you do typically find more release language that is more general there. So that's generally accepted at that point because the project should be over. Make sure when you check the release, you see if there's any terms about a default. If anybody defaults on a release, you want to know, is there a choice of law? What are you going to be filing this in Texas and under Texas law? Are you going to be arbitrating a dispute of a release? Is there attorney's fees if someone has to enforce this release? So this is not, the terms of it in a default are not going to show up for a Massachusetts mechanics lien release or waiver necessarily, but more if there is something being built into it where it's a broader release, so maybe a general or a limited release overall of all rights, or perhaps as you get to a final mechanics lien waiver and release, you may see it where that's more built out and it has more terms about all of the releases that are, all of the claims that are being released, not just a mechanics lien. That's probably where you'll find terms about a default. If you are dealing with a party that is out of state, always good to make sure that you have choice of law, which is which state's law applies, and also the venue where a dispute will be held. Lastly, on the release, make sure it's executed. If you have electronic signatures, you do need to put in a provision that says electronic signatures are acceptable. And last thing I'll cover today is how to get you paid. I want you to use some caution when you're executing the release and exchanging it for payment. I'll interject a quick story here. I had a big mediation one day. I was also trying to close a settlement, which included the exchange of some shares of stock and payment. I did not have the final signed documents from the other side. And despite the pressure to get it done that day, I did hold up and I would not release the funds, even having them sent and even having opposing counsel say, I'll hold the check. I said, nope, I need the documents first. That's how this draft was drafted. That's how this agreement is supposed to operate. And I'm not going to allow you to not give me the written signed full documents first and just send you over the money. So if you're the one in charge of the money, don't send it out until you get that signed release. And if you're the one accepting the money, make sure that the money is coming in the form that you've asked for. I always recommend wire is the absolute best way. It is quick and it is something that you can make sure that arrives. It is basically the safest way to have it happen, especially if you use a phone call to verify the terms of the wire information. Bank check is the next best way to do it, although there have been forgeries of bank checks, or people could lose bank checks. So that's a secondary form. Again, I prefer wire. My least favorite form is, of course, a company check. Those are very easy to stop payment on, and they may not be good. Make sure that the release is stating when it is effective, and if you need to do anything as part of the exchange, if you need to offer something else in addition, or the exchange needs to happen a particular way, make sure you're satisfying that term. And lastly, if there's any question about timing, because oftentimes people say, bring the release and I'll give you the check, and it's a one-for-one contemporaneous exchange. If you can't do that, consider using an escrow agent. It doesn't have to be anything particularly formal, but you could have your attorney hold the money and wait till the release comes into the attorney. And that way you don't have to worry about it being exactly contemporaneous. You can have the attorney just make sure that you're designated what the terms of the escrow are and when things are to be released. But that's another way to handle it. So hopefully I've given you a little bit of information about what the types of releases are that you may see, things to be on the lookout for. And again, that checklist that gives you the opportunity to run through and make sure that these things are included with releases that you're signing and releases that you are expecting other people to sign. So thank you for your time. If we have any questions, Jesse will let me know.
First of all, thank you. You are incredible as always. Again, I want to reiterate exactly what you said. Read your contracts. It is very, very important to read those contracts, read your releases, read what you're signing. If it's something that is presented by your customer, most likely it's going to have language in there that's going to be more beneficial to them. So please make sure that you are reading and understanding exactly what it is that you're signing. Like Jessica said, if you don't understand it, if you have questions, ask the questions. Speak to an attorney, have them help you out with it. It's really, really important. As far as questions, we do have one that came through. This one says, can I file a Massachusetts lien if I'm unlicensed?
Yes, license is not required in order for you to file a mechanic's lien. Anybody can do it. You don't have to be a corporation. You don't have to be registered to do business in Massachusetts. A lien is simply your right to get paid. If you are unlicensed and you are doing work that requires a license, you may ultimately have issues with your lien at the end of the day with enforcing it, because if you are not licensed, you may have an issue getting a permit. And if you do work without a permit, you would be in violation of the building code, and you may have a material breach of your contract if you have not properly permitted that. But when in doubt, I would absolutely go ahead and get that mechanic's lien initiated and on file. You can deal with those issues later on when you talk about perfecting and enforcing your lien.
All right, wonderful. Another question that came through, it says the recorded lien must be mailed. Does that apply to the statement of account? Does the recorded statement of account have to be mailed as well, or just the executed unrecorded document?
Excellent question. So this goes back to the procedure for mechanic's liens. what happens is that notice of contract, if you are not the general contractor and have the direct contract with the owner, then anybody else, subcontractors, sub-subs, vendors, anybody down the chain, they must send a copy of the mechanics lien to the owner. You must be able to prove that they have received it. That is the only document that needs to be sent in that manner. So again, that's just the notice of contract. You do not need to send a copy of the statement of account. The idea is that it puts the owner on notice that somebody else has initiated a lien. Once the owner has that, the owner can then go to the Registry of Deeds and follow up with that from a deed perspective, or they can call the person who's initiated the lien and get more information. So the notice to the owner is just about that first notice of contract document. You do not need to send the other ones. As you get to perfecting your lien by doing the statement of account and then timely filing a complaint, the complaint obviously must be served. That's part of the litigation process, but that's different and that's typically handled by your counsel. The direct answer to your question is you are correct. It's just the first notice of contract that needs to get sent to the owner.
Okay, perfect. Thank you so much for that clarification. And then one other question that came through, can attorney's fees and filing fees be included in the lien amount?
No, for the most part. If you are the general contractor, they can be, but typically a general contractor is not filing a mechanics lien because they're the ones who has a direct contract with the owner. The reason you can do it if you're a general contractor is because your contract with the owner likely says that you can recover your attorney's fees and costs. Anybody else who signs a contract with the general contractor or with another subcontractor, your rights to recover attorney's fees only exist if they are in the contract, and they only exist to the party who signed the contract with you. So if you're a subcontractor, you do not have the right to recover your attorney's fees from the owner. So those fees cannot go into the mechanics lien. However, you do have the right to recover from the general contractor who signed your contract. So as it comes to the lawsuit that perfects your mechanics lien, you would likely include a claim against the party you contracted with. Again, if you're the subcontractor, that would be the general contractor. Your claim against the general contractor would include the attorney's fees claim. But the value of your mechanics lien is just going to be the value of the products and services that you provided. It does carry interest, but not attorney's fees.
Okay, wonderful. Thank you so much for clarifying that. That does seem to be all the questions that have come through. If anyone does think of another question that we haven't addressed, please feel free to email me or Jessica, and we'll be sure to answer any questions for you and run through specifics. Can you go to the next slide? Perfect. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Remember, every state is unique and different on what documents and deadlines are required. So please check that out. If you are working in a nearby state, go onto our site, check out that state, what your role is on that project, etc., and it will help you get that answers of what's required. If you don't mind, give us a quick review on Google. We really do appreciate any of the feedback that you can provide to us. And it would just help us get that information out. And with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Thank you again, Jessica. You really are wonderful. So thank you. And I hope everyone has a beautiful and wonderful sunny day. Thanks again, everyone.